Good morning, everybody. Before we start, I would like to mention a few matters. We have before us two appeals, one from England and Wales and one from Scotland. They both involve the same issue: whether it was lawful for the Prime Minister to advise Her Majesty to authorise the prorogation of Parliament by order in Council. That this is a serious and difficult question of law is amply demonstrated by the fact that 3 senior judges in Scotland have reached a different conclusion from 3 senior judges in England and Wales. The Supreme Court exists to decide such difficult questions of law, and we shall do so in accordance with our judicial oaths, to do right to all manner of people, according to the laws and usages of this realm, without fear or favour, affection or ill will. It is important to emphasise that we are not concerned with the wider political issues which form the context for this legal issue. As will be apparent when we hear the legal arguments, the determination of this legal issue will not determine when and how the United Kingdom leaves the European Union. As is usual, we shall hear arguments from each side in each appeal. First the appellants and then the respondents. We also have a small number of interventions from interested parties, including one from Northern Ireland, where the courts have not considered the prorogation issue, at least yet. For obvious reasons, these appeals have had to be heard at very short notice. We are grateful to everyone involved, the parties and their legal teams, and in particular the court staff, for their hard work in preparing for this hearing, for the written materials so promptly delivered, and for the cooperative way that everyone has worked with one another. As usual, these proceedings are being live streamed so that anybody who wishes to do so and has access to a computer can watch the arguments as they unfold. This is a very important aspect of open justice, and we hope that it will enable many people to understand what these appeals are all about, and just as importantly, what they are not about. Lord Pannick.
Morning, my ladies, my lord. May I, on behalf of all of us, thank the court and the court staff for facilitating so speedy an appeal on these important matters. The court has a list of counsel appearing in these appeals. On behalf of Mrs. Miller, I want to make a submission on what we see as the 3 main points which arise on these appeals. May I please identify these issues and then develop my submissions on each of them. The first of them is we say on the facts that the Prime Minister advised Her Majesty to prorogue Parliament for a period as long as 5 weeks because he, the Prime Minister, wished to avoid what he saw as the risk that Parliament during that period would take action to frustrate or to damage the policies of his government. And on this first issue, we will adopt the substance of the reasoning of the inner house of the Court of Session and briefly add some further points, in particular on the relevance of the failure of the Prime Minister to produce a witness statement, either by himself or by the Cabinet Secretary, responding to the allegations as to his motive. The second matter I will seek to address is that we will say that it is elementary in public law that a power may only be exercised for a proper purpose. And we will say that that principle applies to prerogative power as it does to statutory power. we say it is an improper purpose for the Prime Minister to use the power of prorogation because he wants to avoid the risk of Parliament undermining the policies of the executive during the relevant period. And that is because under our system of constitutional law, Parliament is sovereign and the executive is accountable to Parliament. For the executive to use a prerogative power to seek to evade control by Parliament stands the basic principles of constitutional law on their head. It conflicts with the basic principle of our constitutional law, stated by Lord Brown Wilkinson. I'll take the court to the authority later, but let me give the citation. It's in the Fire Brigades Union case, Authorities Volume 3, tab 42, at page 552, E to F. And may I quote, "The constitutional history of this country is the history of the prerogative powers of the Crown being made subject to the overriding powers of the democratically elected legislature of the sovereign body." We will say that the arguments for the Prime Minister and the Advocate General assert the constitutional novelty that the powers of the democratically elected legislature are subject to the desire of the executive to avoid parliamentary scrutiny. And our third submission will be, with great respect, that the Divisional Court was wrong to conclude that the issues in this case are non-justiciable. Identifying whether a power has been used for a valid purpose is a legal question. It is not a political question. It's a question for the courts, and the rule of law so demands. This court is not being asked to identify a list of purposes for which prorogation would be lawful, nor is this court being asked to specify what would be a valid period of prorogation. The court is being asked to answer the legal question of whether it is within the scope of the power conferred on the Prime Minister for him to exercise it for the purpose alleged. My understanding is that Lord Keane, my learned friend Lord Keane, is going to address the facts of this case, and my learned friend Sir James Eadie is going to address the legal issues, that is issues 2 and 3. There may be some modification of that, but in substance that's what it amounts to. Can I also say I'm not abandoning the various other ways in which the claim has been put in the written submissions and in the points made by the interveners. And we're very grateful for all the interventions, and I have much of my submissions is derived from the points that are made in them. But I want to focus my oral submissions on what we see as the three main issues. My ladies, my lords, before I develop those 3 points, may I also indicate by way of introduction why we are going to say that the 3 points which are highlighted in the introduction to the written case of the Prime Minister and the Advocate General at paragraph 6 through to 9 have no substance. And they make 3 essential points. First, they say that there are no legal rules, only conventions governing the frequency with which Parliament sits and the length of time between parliamentary sessions. I emphasise we are not inviting the court to specify any such rules. Our case is that when the Prime Minister exercises his admittedly broad discretionary power to advise Her Majesty on prorogation, it is an improper purpose for him to be motivated by a wish to avoid parliamentary control over the policies of his government. The length of the prorogation in this case is important, but it is important not because a prorogation may only be for 1 week or 3 weeks. That is not our case. The length of the prorogation is relevant because the exceptional length of the prorogation in this case is strong evidence that the Prime Minister's motive was to silence Parliament for that period because he sees Parliament as an obstacle to the furtherance of his political aims. The second point emphasised by the Prime Minister and the Advocate General is that there are statutory provisions which regulate, to some extent, parliamentary sittings. Most recently, as the Court will have seen, the Northern Ireland Executive Formation Act of 2019. Our response to that point is that none of that legislation addresses or affects the common law power and duty of this court to ensure that a discretionary prerogative power is not exercised for an improper motive. And the third point that the Prime Minister and the Advocate General emphasise is they say that this complaint is academic, their word, because Parliament was able to sit, and did sit, between the 3rd and the 9th of September, and Parliament will sit again on the 14th of October. They point out that Parliament legislated between the 3rd and the 9th of September, and if it wishes, it will be able to legislate again as from the 14th of October. Our answer to this point is twofold. First, we say if we can sustain our complaint that on the 28th of August, the Prime Minister advised Her Majesty that Parliament should be closed for 5 weeks because he was concerned that Parliament would or may damage the implementation of his policies, then that is an invalid purpose. And it is, with great respect, not for this court to seek to assess what Parliament would, may, or will do during those 5 weeks. If, as we contend, the Prime Minister acted for an improper motive, it is not now open to the Prime Minister to say that his fear was mistaken. But in any event, it is very far from academic that Parliament is unable to conduct such business as it thinks appropriate for the 5 weeks. To put it at its very lowest, Parliament may decide during the 5 weeks, now 4 weeks left, to enact further legislation, informed by the answers to parliamentary questions, informed by debates, informed by reports from parliamentary committees. Parliament may, I don't ask the court to say more than this, but Parliament may want to keep a close eye on the negotiations, if any, with other member states during the period. Parliament may wish to keep a close eye on planning for a no-deal exit during the 5 weeks. And in the light of parliamentary scrutiny, Parliament may wish urgently to legislate during that period. It may wish to impose further obligations on the Prime Minister in the period leading up to the EU Council meeting on the 17th and 18th of October. The issues in these proceedings are very far from academic. The Prime Minister and the Advocate General say at paragraph 77 of their written case that there is no authority which supports the proposition that the exercise of a power to prorogue the legislature is amenable to judicial review. Our response, which I will develop, is that there are many precedents establishing the relevant principles of our constitutional law. There has hitherto been no need for any court to apply those principles in the context of the prerogative power to prorogue, because no Prime Minister has abused his powers in the manner which we allege in at least the last 50 years. That is, back to the development of modern principles of judicial review.
Well, could I just raise one point there? I mean, is it right that there is no authority in this country or anywhere else as the use of judicial review to control prorogation? Because I was particularly interested in reading Anne Tromey's book called The Veiled Sceptre, which deals with prorogation in the sort of Westminster model. And it's quite clear from that the sort of issues of misuse or alleged misuse of power have come up on many occasions in many different jurisdictions.
Not in courts.
No, but that's why I was just wondering why not, given that they clearly, are we just looking at this country? Are we looking rather more broadly at experience in the common law world?
We found, and the other side have found, no judicial authority. And I'm suggesting that the reason in this country, at least, why no case has come to court is because nobody has identified any similar factual circumstance in which the principles have needed to be applied. But I do say that there are well-established authorities as to the principles that should be applied in the circumstances of such a case. My ladies, my lords, one other preliminary matter. We say that Her Majesty the Queen enjoys no personal prerogative in this context. Her Majesty was obliged to accept the advice from the Prime Minister. The Prime Minister and the Advocate General disagree on that issue. See paragraph 35 of their written case, but they add, and we agree, I quote, "This is not an issue which arises for determination on the present appeal," end of quote. It may assist the court also just if I draw attention to what happened in this case, because on the 29th of August, the Lord President of the Privy Council, Jacob Rees-Mogg, was one of the Privy Councillors who attended on Her Majesty at Balmoral, and he has described how Her Majesty formally approved the Prime Minister's request to prorogue Parliament. And if the court, please, has the trial bundle in the Miller case, the court will see at tab number 51,
Do we
which
have
is
this
page-
do we have this electronically?
yes, it's page 373. I hope the court also has it electronically.
Well, we have no less than, I'm sorry about this, but there's always trouble with the documents in these cases, and we need to sort it out. We've got 5 different documents on a memory stick. Is it the hearing bundle?
Yes, it's called the trial bundle for hearing on 5th of September. I hope that is the same document as the President is referring to. It has 68 tabs, maybe more than 60.
How many pages has it got? Oh, yes.
My
yes.
volume goes up to page 518.
Well, mine goes up to 591.
Oh, but
As
then
does
it-
mine, I'm
Yes,
afraid.
so-
I think it's could I ask the court to turn to tab number 51, which is page 373?
Let's see whether it works, yes. 373.
Yes, that should be an interview on the Today programme, and it was an interview, Mr John Humphreys interviewing Jacob Rees-Mogg.
I'm afraid not.
It isn't.
Well, then it's a different bundle.
I
Does
don't
the-
think I think it may be the same bundle, but it's a,
A different
page.
page. I'm very sorry about this.
No, but it's not your.
Lord Panic.
Of course, it's not the President's fault. Does the court have tab 51?
I do, but nothing happens when I press on it. Put it on paper.
I'm terribly sorry, but it may be that we can try to sort that out and we use paper for the moment.
It's page 436, I think, but nothing
Well, I'm very
happens.
grateful.
Nothing.
Nothing happens.
Yes. 436.
Yes.
Does the President have that number? Have
Yes.
that page? I'm
Yes.
grateful.
Yes.
I don't know why the numbering is different, and I'm very sorry, and it's very inconvenient for everybody, in particular the court. But if we turn over to the second page of that document, which I have at 374, at the end of that page, Mr Jacob Rees-Mogg explains that it's simply wrong. The Queen, Her Majesty, had no discretion over this. There is no precedent for the Queen refusing a request by her Prime Minister under these circumstances. This is a straightforward decision by the Prime Minister giving formal advice to the Sovereign, which a constitutional monarch is obliged to follow. And on the next page, for those of the members of the court using the paper volume, it's page 375. At the bottom of that page, Mr Humphreys, and the same when you said the Prime Minister wishes to prorogue, etc., she would just say approved. Mr Jacob Rees-Mogg, that's absolutely right. It's important that people understand this is a prime ministerial decision. It's not a decision of the Sovereign and hasn't been, etc., etc. So that's what happened in practice. Her Majesty was advised that it was a matter for the Prime Minister, but as I've indicated, nothing turns on this, but it's the reason why we, for our part, are making no criticism of Her Majesty in these proceedings. Her Majesty acted on the advice of her Prime Minister. That's what I wanted to say, my lady, as by way of introduction. Can I turn to the first main issue, and that is the facts of this case? And I can be brief on this subject because we agree with the analysis by the Inner House of the Court of Session, in particular Lord Brodie at paragraph 89 and Lord Drummond-Young at paragraphs 120 to 123. And the essence of their reasoning is that the Prime Minister had made clear that he is determined that this country will leave the EU on the 31st of October, deal or no deal. The Prime Minister does not have a majority in the House of Commons for a policy of leaving, if necessary, with no deal. The Prime Minister has given no sensible reason, indeed no reason at all, for the exceptionally long period of this prorogation. And the Prime Minister as the evidence shows, sees Parliament as a threat to the fulfilment of his policy. I want to emphasise 2 points, if I may, additional to those made by the Inner House. The first is that there is evidence in the form of statements by the Prime Minister himself, which shows that the Prime Minister regards Parliament as at least a potential threat to the implementation of his policies. And there are 2 interviews with the Prime Minister. The first is by Sky News, and the court will find that interview in the same trial bundle. I have it at tab 54, which is page 400. I hope the court will be able to tell me where electronically the court has it, but in my bundle, it's trial bundle tab number 54, page 400. And it's an interview, a Sky News interview with Boris Johnson by the journalist Sam Coates. And if the court, please, would turn to the transcript, at the top of the page, Mr. Coates asked the question, when people voted for Brexit, they were voting for Parliament to take back control, but now you, as Prime Minister, are trying to limit the ways that Parliament can express its view because you disagree with them, etc., etc. And Mr. Johnson then responds, and the court will want to read all of this, but can I highlight at the bottom of the page, the final paragraph? The Prime Minister says this: just to get back to Parliament, which I bet you are going to ask me about, just to get back to Parliament, I am afraid that the more our friends and partners think at the back of their minds that Brexit could be stopped, that the UK could be kept in by Parliament, the less likely they are to give us the deal that we need. And so that is why I really hope that MPs will allow the UK to do a deal, get ready for a no-deal Brexit, and that is the best way forward for our country, believe me. This was immediately after prorogation. This is the 30th of August, 2019. And to
The electronic number, Lord Pennick, is 464.
Yes.
Very grateful. I'm terribly sorry about
That
this.
means it's 63 pages on from the number you have.
Yes, well, I'm sorry.
I feel sure somebody can help you.
I'm sure
Very well.
mental
So I had
arithmetic,
63. Well, then the next...
mental arithmetic is up
next-
to it, I'm sure.
It may test my abilities, but the next number, the next page that is relevant, I have at tab 55. I have at page 408. And adding 63 to that takes us to 471. And this is a BBC report, page 408 or page 471.
Yeah.
On the second page of that, 409, the third paragraph up from the bottom, we see that Mr. Johnson was speaking to the BBC, and on the final page, not the final, penultimate page of this document, 473, about a third of the way down the page, there's a paragraph, he said, and that's Mr. Johnson, the best way to leave with a deal is if our friends and partners over the channel don't think that Brexit can be somehow blocked by Parliament. As long as they think in the EU that Parliament might try to block Brexit or might even succeed in blocking Brexit, the less likely they are to give us the deal we want. Now, I'm of course not asking this court to say whether the Prime Minister's assessment is correct or is incorrect. The relevance of these statements is that they are strong evidence to be added to the material referred to by the Inner House as to the Prime Minister's motive in deciding to close Parliament for 5 weeks during this negotiating period. The other point I want to make on the facts is that it is, we say, a remarkable feature of these proceedings that the Prime Minister has not made a witness statement explaining why he decided to advise Her Majesty to prorogue Parliament for a period as long as 5 weeks. And that is even though we made very clear in commencing these proceedings that an important part of our case is that the Prime Minister's advice to Her Majesty was motivated, or at least strongly influenced, by the Prime Minister's desire to prevent the risk, as he saw it, of Parliament damaging government policy. And we set that out in our Statement of Facts and Grounds, dated the 28th of August, which is in the trial bundle at tab 2. If the Prime Minister did not wish personally to make a witness statement, such a statement could have been made by the Cabinet Secretary, as in the GCHQ case. The only witness statement from the government side is from the Treasury Solicitor, whose statement is confined to the production of documents. The Treasury Solicitor, Mr. Jonathan Jones, could not give evidence as to the Prime Minister's reasons for advising a 5-week prorogation. My ladies and my lords, of course, the production of a witness statement from the Prime Minister, or indeed anyone else, setting out the reasons for advising on a prorogation as long as 5 weeks would have had legal consequences. And the legal consequences of such a witness statement would have been almost inevitably an application to cross-examine. The legal consequences would also be that it would be a contempt of court, of course, for such a witness statement not to tell the truth. Our submission is that the documents pose more questions than they answer, as the Inner House has pointed out. And in any event, the production of those documents is no substitute for evidence from the Prime Minister or from someone on his behalf stating to the court in terms why he thought a prorogation for the exceptionally long period of 5 weeks was appropriate. We draw attention to the decision of the Court of Appeal in the Das case. Now, this appears, I hope, in the supplementary authorities bundle, supplemental authorities bundle at tab number 19. It's volume 1 of the supplemental authorities bundle, volume 1.
Yes.
I hope it's at tab 19. It does not have, I'm afraid, a page number.
Well, it's 292 on the supplemental authorities.
I'm grateful. I'm grateful.
I've got several supplemental authorities.
Supplemental Authorities, Volume 1, tab 19, Queen on the application of Das against the Home Secretary.
Yes.
Supplemental bundle.
And the relevance of this case is that it approves the test stated at first instance by my Lord Justice Sales, sitting at first instance in that case, as to the applicable test relevant to this principle that I am relying upon. And that appears in Das using the numbering in the report right at the end, page 3565, 5. If I may,
Panic, I'm afraid some of us are struggling here. I've got a supplemental authorities bundle produced by your solicitors
yes.
that goes up to tab 12.
Oh dear.
I've got a supplemental authorities bundle 2 produced by your solicitors, which starts at 35.
Then
But you want one in the middle.
I do, my Lord. I'm terribly sorry. Maybe the best thing to do is if we hand up to those members of the court who, and I anticipate from the signs I'm receiving that, my Lord, the Deputy President is in the same position. I don't know whether, and so we need a number of copies, please, urgently, of the DAS. Can we just have DAS? Can we just have tab number 19? We can hand up. I'm terribly sorry about this.
I've got it.
What page?
35. It's within the report, 3565.
With the assistance of the hand up.
We don't have electronic pages. Tab 19 of the Supplementary Authorities Bundle. The updated Supplemental Authorities Bundle.
They're just coming here.
We've got the updated Supplemental Authorities. Should be updated.
Take it to the President first.
It's in the what? 1481 in the Cherry bundle. Yes, it's also in the in bundles authority in the Cherry.
1481.
Ah, yes. Number 13. Yes, I have that.
Volume, it also appears at Authorities, Volume 1, tab 13.
Yes.
Grateful. And the page number is
Lord
page...
Panic, it does appear that there was initially produced supplementary authorities bundle.
Yes.
Then it was enlarged.
Yes.
Then there came number 2. And you've got to decide whether we all need to have, for the purposes of this appeal, the enlarged bundle.
Well,
and if so, as soon as possible.
Well, indeed, my Lord. Absolutely.
But if you can actually use the Scottish
Well, I can for this case. Yes, I can for this case.
that may be enough.
Yeah. But it is for DAS. I'll have to check whether there are other authorities that the court needs to look at and doesn't have. Tab number 19 in the Miller case, 13 in the Cherry case, is the DAS authority, and it's at page 3565. It's paragraph 80. And counsel for the Secretary of State is submitting that there's no obligation to file witness evidence. She urged the court not to punish the Secretary of State for not filing evidence. She referred to the scarcity of resources, heavy litigation burden on the Secretary of State, the need to prioritise resources on those currently detained, none of which factors are relied on, of course, in the present case. And the Court of Appeal, this is Lord Justice Beatson, then approves the statement at first instance by the judge, my Lord Sales. He observed, where a Secretary of State fails to put before the court witness statements to explain the decision-making process and the reasoning underlying a decision, they take a substantial risk. In general litigation, where a party elects not to call available witnesses to give evidence on a relevant matter, the court may draw inferences of fact against that party. The basis for drawing adverse inferences of fact against the Secretary of State in judicial review proceedings will be particularly strong, because in such proceedings the Secretary of State is subject to the stringent and well-known obligation owed to the court by a public authority facing a challenge to its decision. In the words of Lord Walker for the board in the Belize case, to cooperate and to make candid disclosure by way of affidavit of the relevant facts, and so far as they're not apparent from contemporaneous documents which have been disclosed, the reasoning behind the decision challenged in the judicial review proceedings. And we rely on that statement of principle. We say that at best, from the Prime Minister's point of view, the documentary material, that is the material referred to by the Inner House, and the statements to broadcasters to which I have referred, are at best, from the Prime Minister's view, ambiguous about whether his concern about Parliament potentially damaging negotiations was his motive, or an important part of his motive, for advising on an exceptionally long prorogation. We say this case cries out for an answer in a witness statement to the allegation that was made against the Prime Minister. And in the absence of such a witness statement and the willingness of the Prime Minister to submit to potential cross-examination, we say the court should infer that there is no answer.
You might want to check. I think this question about drawing inferences in the absence of reasons is considered in Padfield.
Yes, it is. It is. I'm going to come to Padfield.
Oh, right.
Your Lordship's, of course, correct. There are many cases where this point has been addressed. I was also going to mention the GCHQ case, where, of course, issues were raised about national security, whether or not the decision of the then Prime Minister to remove the right to trade union representation at GCHQ without consultation because of national security considerations was the subject of witness evidence. It was the subject of an affidavit from the Cabinet Secretary, and the appellate committee in that case, notwithstanding the very sensitive subject matter, made it very clear that the government needed to produce evidence to support their claim that there were national security considerations. Sir Robert Armstrong produced an affidavit. Can we look, please?
It may not matter, but I think Lord Walker was dissenting, wasn't he, in the Belize Alliance case? And, I mean, you said for the board, I think he was dissenting. I don't know whether that statement, which is very clear and helpful, has been adopted either by this House, by this court, or by the board.
Well, we can check that. It's certainly been accepted as the judgment of my Lord Sales indicates, approved by the Court of Appeal in that case as the governing principle, certainly in the context of public law, that if an allegation is made, a factual allegation, and the material is at least ambiguous, one expects the minister or someone on his behalf to answer that.
No, I mean, I'm not questioning the principle. I just think it'd be clear, useful to have a most authoritative statement of that.
Can we look, see if we can find that? It may be that there isn't, otherwise my Lord Sales would have referred to some approval, I'm sure, of the principle stated by Lord Walker. But we say that is the principle. Can I show the court, please, the GCHQ case? That is in the Miller Bundle of Authorities, Volume 1, and it appears at tab number 11. And the relevant passages, very familiar case, of course, the relevant passages that we rely upon, first Lord Scarman at page 404, picking it up at page 404, letter E, just under letter E.
Do you know the electronic number of that, or again, are you not unable to help us?
Yes, well, has Authorities Bundle Miller, Volume 1, and it's at tab 11.
It's 31.
It's page 31 of the 51 pages, yes.
And if the court turns using the internal numbering at page 404, internal numbering, because I'm afraid I don't have the electronic numbering, page 404, just under letter E, Lord Scarman says the point of principle in the appeal is as to the duty of the court when in proceedings properly brought before it, a question arises as to what is required in the interests of national security. And then picking it up again at G, though there are limits dictated by law and common sense, which the court must observe in dealing with the question, the court does not abdicate its judicial function. If the question arises as a matter of fact, the court requires evidence to be given. If it arises as a factor to be considered in reviewing the exercise of a discretionary power, evidence is also needed so the court may determine whether it should intervene to correct excess or abuse of the power. And on the preceding page, page 403, just under letter B, the court sees that there was evidence. There was evidence from Sir Robert Armstrong, the then Cabinet Secretary, who addressed the relevant issue of facts. And at page 420 of the report, at letter E, Lord Roskill is to like effect, 420 letter E, the courts have long shown themselves sensitive to the assertion by the executive that considerations of national security must preclude judicial investigation of a particular individual grievance. But even in that field, the courts will not act on a mere assertion that questions of national security were involved. Evidence is required that the decision under challenge was in fact founded on those grounds. That principle exists is, I think, said Lord Roskill, beyond doubt. And then he goes on to the merits of the matter. So we respectfully submit that on the facts of this case, the Inner House was correct in its analysis and conclusion as to the motive of the Prime Minister. Their conclusions, we say, are supported by the Prime Minister's own public statements as to his concerns as to what Parliament may do, and the court, in addition, should be prepared in the circumstances of this case to draw an inference from the absence of any evidence on the government side by way of witness statement as to the answers to the allegation from the Prime Minister, or indeed from the Cabinet Secretary on his behalf. We submit that on all the material, the court should conclude that but for the Prime Minister's wish to avoid parliamentary control, he would not have recommended to Her Majesty a prorogation for a period as long as 5 weeks. But he would have recommended a substantially shorter period in order to allow for a Queen's speech, the closing of one session, the opening of another, as had occurred on every occasion, that is a shorter prorogation, on every occasion in the last 40 years. If the court accepts our submission that there was here an improper motive, it is for the Prime Minister to satisfy the court that it was not material to the decision that he took, and he can't do that in the absence of any affidavit or witness statement. That's what I want to say in answer to the first part of the case. Lord Keane, of course, will respond for the government by way of answer to the decision of the Court of Session, and my friend Mr. O'Neill will have the opportunity to address the points that Lord Keane made. But that's what I want to say in opening on that part of the case. Can I turn to the law? The second part of my submissions concerns our contention that for the Prime Minister to advise Her Majesty to prorogue Parliament for a period of 5 weeks in order to avoid what he saw as the risk of Parliament undermining his negotiations is to use the prerogative power for an improper purpose. And we say it's well established in public law that a power conferred on the executive may only validly be used if it is for a proper purpose. Excuse me for my apologies. Thank you. No, not at all, thank you. And this is a principle which can be traced back to the 17th century and traced back in modern times to Padfield. The matter is addressed by the learned authors of De Smith, which I hope the court will find in supplementary authorities at tab 16, although that too may not...
De Smith's Judicial Review.
Smith's Judicial Review. De Smith.
Yes.
Judicial Review, tab 16 of Supplementary Authorities, Volume 1.
I think this supplemental authorities bundle is entitled Updated Supplemental Authorities.
I'm grateful.
It is electronically, at least.
Page 193, anyway.
Yes.
There is apparently, I'm told, an envelope that some members of the court may have with the updates. That may be the answer.
Yes, because I had DAS, but I'd opened the envelope, so possibly that's the explanation.
I appreciate some members of the court may not have appreciated that there are We'll sort this out over the short adjournment, but I hope that members of the court will have the updated material. It's tab number 16 of the Supplementary Authorities, Volume 1. I'm grateful. That's the answer. It's probably not the most difficult question in this case, but it's the answer to that question. Supplementary
Well spotted by the young lady behind
Indeed,
you.
I'm very grateful to Emily from Mishkons. The court will see at paragraph 5009, which is the second page of this insert, that the learned authors, who of course are Lord Wolfe, Professor Jow, Catherine Donnelly, Ivan Hare, they describe the origins of this principle back to the 16th century, and the court will no doubt wish to look at that. But at 5-018, we come to modern times, and we come to the decision in 1968 of the House of Lords in Padfield was an important landmark. And it reminds us of the context. The minister had refused to appoint a committee, as he was statutorily empowered to do at his discretion, to investigate complaints made by members of the Milk Marketing Board that the majority of the board had fixed milk prices in a way that was unduly favourable to the complainants. The House of Lords held that the minister's discretion was not unfettered, and that the reasons he'd given for his refusal showed that he'd acted ultra vires by taking into account factors that were legally irrelevant and by using his power in a way calculated to frustrate the policy of the Act. And we have at Padfield in the same volume, tab 18.
But I mean, this is a statutory.
Yes, it is. I have to satisfy the court that the same principle applies in the context of a prerogative power.
Yes, I mean, we may not need to look at Padfield for the statutory.
Well, it sets out the basic principle. Can I very briefly just identify what the basic principle is? And it's Lord Reid at page 1030, between C and D, very familiar. Parliament must have conferred the discretion with the intention that it should be used to promote the policy and objects of the Act, and they must be determined by construing the Act as a whole. Construction is always a matter of law for the court. If the minister, by reason of having misconstrued the Act or for any other reason, so uses his discretion as to thwart or run counter to the policy and objects of the Act, our law would be very defective if persons aggrieved were not entitled to the protection of the court, so it is necessary first to construe the Act. And then over the page, at page 1032, is the point that my Lord the Deputy President was averting to. At the bottom of 1032, it was argued that the Minister is not bound to give any reasons for refusing to refer a complaint to the committee, that if he gives no reasons, his decision cannot be questioned. And it would be very unfortunate if giving reasons were to put him in a worse position. But I do not agree, says Lord Reid, that a decision cannot be questioned if no reasons are given. If it is the Minister's duty not to act so as to frustrate the policy and objects of the Act, and if it were to appear from all the circumstances of the case that that has been the effect of the Minister's refusal, then it appears to Lord Reid that the court must be entitled to act. And then I emphasise the following sentence. A number of authorities were cited in the course of the argument, but none appeared to Lord Reid to be at all close to the present case. In other words, his lordship was not deterred by the absence of a clear precedent. His lordship proceeded, as I am inviting this court to proceed, by reference to principle. The speeches of the other members of the appellate committee were to like effect, and without taking the court through them, they were Lord Hodson in particular at 1049 E to G, Lord Pearce at 1053G to 1054A, and Lord Upjohn at 1061E to 1062A.
It might be said that there is there's a different nuance here from the passage that you cited from Mr. Justice Sales, that rather than drawing an analogy with a failure in ordinary proceedings to lead an available witness, and therefore being inclined to draw an adverse inference against a party, it's put here more in terms of looking at all the circumstances and deciding what inference should reasonably be drawn.
Yes, but in my submission, the absence of a witness statement that addresses what is otherwise at least a strong prima facie case is a relevant consideration for the court to address. Public law has moved on in my submission since 1968. The approach in 1968 was that the minister cannot simply say, I have no duty to give reasons. The modern law is strongly influenced by the development of duties of disclosure and a recognition that a minister can be expected specifically by evidence to address a complaint. But I recognise this case is not of itself authority.
But it's also interesting, isn't it, that Lord Reid was speaking of if it were to appear from all the circumstances of the case that that had been the effect of the minister's refusal to do what he should have done.
Yes, indeed. One looks at the consequences of what is happening. It's the purpose and the effect are both relevant in this context, and if the inevitable effect is to frustrate the operation of parliamentary procedures, that assists in identifying the motive of the minister.
But might it be unlawful if the effect was to do that, even if that was not determined to be the motive?
Well, that is our alternative way of putting the case, that we have put the case at all stages by reference to the motive of the Prime Minister and by reference to the inevitable effect that the Prime Minister's decision to close Parliament for 5 weeks inevitably, in the context of this case, has a very damaging impact on the ability of the legislature to scrutinise the actions of the executive. Indeed so. And we are not wedded to a solution that involves a finding of a wrongful motive. We have put the case in both ways.
The gravamen of your complaint is really the effect on parliamentary accountability, parliamentary scrutiny, the opportunity to legislate. Yes. And even if there had been no intention to block all that in order to pursue a particular government policy, you would still have the same complaint, would you not? Well, at least a stronger complaint, albeit you'll be putting it in a different way.
Well, one can put it either way. At its very lowest, the Prime Minister's decision to prorogue for a period as long as 5 weeks prevents Parliament from performing its scrutiny functions over the activities of the legislature. It means Parliament cannot legislate and it cannot inform itself for the purposes of legislating by the asking of parliamentary questions, by holding parliamentary debates, by the reports of parliamentary committees, all at a time when we say it is self-evident that Parliament will or may wish to carry out such activities.
Do we have evidence about questions being put and not being answered as a result of the prorogation?
Well, as a matter of principle, questions cannot be put. Once Parliament is prorogued, it is simply not possible for parliamentary questions, written or oral, to be tabled.
But were any tabled and not answered?
The questions that were asked before prorogation, I suspect there were, but we don't have the material. I can seek to find out the answer to your ladyship's question. But as a matter of principle, any development, and there are inevitably developments, as from the 9th of September, cannot lead to any parliamentary question being asked, written or oral, by any member of Parliament. Parliament is closed. You cannot, as a member of Parliament, member of the Commons, member of the Lords, you cannot ask any question. And that is made clear in the material before the court. It's made clear, if the court wants to have document in the briefing paper from the House of Commons, which is in the main bundle at the hearing bundle, trial bundle, tab 29. It's the House of Commons briefing paper. It's page 169, and adding, 63 pages, takes us to 232. But I have it at tab number 29 of the trial bundle. And and the relevant passage, if the court has that document, is at page 180 in the paper version, 223 in the electronic version. In the middle of the page, neither House of Parliament sits. During prorogation, Parliament does not meet. This means legislation cannot be considered or introduced by MPs and peers. Debates in the Chamber or Westminster Hall are not held. Written and oral parliamentary questions cannot be asked. Committees do not carry out the usual business of inquiries and evidence taking. The temporary suspension of activity is not normally significant, as a new session typically begins shortly thereafter. For a longer prorogation, however, this suspension of activity weakens the ability of parliamentarians to hold the government to account. That's the undisputed position. There will inevitably, thinking about your ladyship's question, there will inevitably have been parliamentary questions that were pending on the 9th of September, which will not have been answered and will not now be answered until the 14th of October. But the point I emphasise is that Parliament is prevented from responding to whatever developments there may be, and it's not difficult to see that there are and will be developments as from the 9th of September.
Do we have evidence of what other business was lost? I mean, there were a number of bills.
Yes, there were.
Is there evidence about that?
We can try to find that for the court. Some of those bills, I accept, will be reintroduced once Parliament resumes.
So that's not an aspect to rely on particularly?
Well, it's not in the forefront of my submissions. The forefront of my submissions is that in the circumstances of this case, we say the plain effect of the Prime Minister's decision that Parliament will not sit for 5 weeks is to prevent Parliament from performing its scrutiny functions, which include legislation, in response to whatever developments there are not.
But an important part of this case is the distinction between Parliament adjourning, going into recess,
Yes.
And prorogation.
Absolutely.
And an important feature of prorogation is that, in most circumstances, bills that are currently under consideration are lost.
Precisely so.
And it would be of great interest to us to know which bills were lost.
We can find out. We will find out the answer to the question put by the President, by my Lord Carnworth. Of course, during a recess, by contrast with prorogation, parliamentary questions can be asked and they are answered. During a recess, parliamentary committees continue. They produce their reports. And of course, a recess is a judgment made by Parliament itself. Parliament decides when it is going to recess. There's a need for a motion before the House. So just finishing this submission, Padfield, the authors in De Smith, and I was showing the court the relevant passage in De Smith, they make the point in supplementary authorities, it was tab 16, they make the point at paragraph 5090.
90 or 19?
90, 5090.
Thank you.
That this is an elementary proposition. That is, that power granted for one purpose may not be exercised for a different purpose. It's elementary, and it is elementary.
Do they deal with the question of prerogative as opposed to the in this context?
De Smith, not that I'm aware of. I will check, but no, we haven't found such a statement. Now, in the context of a statutory power, identifying the proper purpose for which the power may be used is, as Lord Reid said, a matter of construing the legislation. assisted, of course, by legal principles which the court applies. In the context of a prerogative power, the exercise is more complex because there is no statute. But we say it's not different in principle. It's still for the court to identify what are the purposes, what are the impermissible purposes for which the power may be exercised. And this has been the subject of analysis by Professor Mark Elliott. And can I invite the court's attention, please, again to the supplementary authorities. And it's at tab number 15 of the supplementary authorities. And it's the analysis by Professor Mark Elliott, published on the 12th of September, relating to this case. And it's in the light of the judgment of the Divisional Court. And if the court, please, goes to the second page of this document, in the first new paragraph, Professor Elliott has dealt with justiciability, to which I'm going to come. And he says, once the starting point is clearly established, other crucial matters follow. First and importantly is the widely recognised principle that no government legal power is unfettered. All legal powers held by the government are legally finite, and their boundaries are determined, among other things, by reference to the purposes for which they may and may not legitimately be used. There is no good reason why this should not apply in the case of the prorogation power, and the government's ancillary authority to advise the Queen as to its exercise. It follows that those powers are legally limited, among other things, by reference to the purposes for which they may and may not legitimately be used. What those purposes are is a legal question for determination by courts in the ordinary way. When such questions arise in respect of statutory powers, they are resolved first and foremost by means of statutory construction. That is, the legislative text is examined and construed by the court, and the purposes for which the power can and cannot lawfully be used are thus determined. However, the process of statutory construction is rarely a purely literal one that entails recourse to nothing more than a dictionary, and it frequently involves the attribution of meaning to the statutory text by reference to broader, relevant, legal, including constitutional principles. And he says that this is so well established that authority is not needed, but he cites the Robinson case, which is Authorities, Volume 4, tab 46, the Sims case, Volume 3, tab 44, and the Fire Brigades Union case, Volume 3, tab 42. He then says, in the next paragraph, in the case of prerogative powers, there is plainly no formal textual starting point, such as there is when statutory powers are in play. It follows that it may be more difficult to determine the boundaries of such powers, including by reference to the purposes for which they can and cannot lawfully be used. It does not, however, follow that no such boundaries exist, nor does it follow that questions as to the location of such boundaries are anything other than legal questions. Just as fundamental constitutional principle may cast light on the proper meaning of statutory texts, and thus on questions as to the proper and improper use of statutory powers, so fundamental principle may illuminate and determine the boundaries of prerogative power, including the purposes to which they can and cannot lawfully be put. And on the next page, in the paragraph, the new paragraph, a third of the way down, in these cases, the question is therefore whether the use to which the power has been put results in the boundaries of the power having been exceeded with reference to any purposes for which the power may not lawfully be exercised. The Divisional Court rightly noted that there are several purposes for which the power can lawfully be exercised, but the question here is whether the power has been used for a purpose for which it cannot be so exercised, and that raises questions of evidence and legal principle. He says he takes no position on the evidential question, Two legal questions then arise. Is the stymieing of Parliament, that's the inner sessions, the inner house's phrase, is it a purpose for which the prorogation power can lawfully be exercised, and is dealing with this matter something that the court can legitimately do, or are the issues non-justiciable? He says, notwithstanding all of the sound and fury, neither of those questions, it seems to him, raise especially controversial or difficult legal or constitutional questions. The first question falls to be answered by reference to fundamental constitutional principle, and one such principle is the representative nature of democracy in the UK and institutional arrangements, including executive accountability to Parliament, that are thereby necessitated. Recourse to such principle in determining the limits of the power should hardly be a controversial step, nor should the conclusion that it is incompatible with the nature of parliamentary democracy for the executive to have a legally unfettered power to suspend the operation of Parliament to shield the executive from parliamentary scrutiny. And that's our case. We say...
I mean, it doesn't... Interesting enough, even someone as knowledgeable on this subject, Professor Elliott, doesn't have any authority to support what he says. He just says it.
No, he says it's constitutional principle. His argument is that just as a statutory power...
Yes, I mean, I understand the argument, but it would be comforting to have some authority. I mean, the only case where I think we'd have to consider this was Sanderford.
Well, we'll come to that. But the difficulty is to the absence of occasions in which prerogative powers have been used with the purpose or with the inevitable effect of undermining a basic constitutional principle, that is here parliamentary sovereignty. It has not occurred. And just as in the Padfield case, Lord Reid said his lordship was not deterred by the absence of a precise precedent, my submission to this court is that it should not be deterred. It should apply fundamental principle. And there are two. The fundamental principle that no power enjoyed by the executive may be used with the purpose or with the effect of undermining fundamental principles of law. And the second limb of the argument is that it does undermine, either as a matter of purpose or as a matter of inevitable effect, a fundamental principle of our constitutional law, which is that the executive is answerable to Parliament. And here, the purpose and or effect of the decision is to remove such accountability, such scrutiny, at a vital time. It's not just Professor Elliott who makes these points. The other leading, I would submit, academic authority of relevance in this area is Professor Craig of Oxford University, and his analysis is in the same bundle, tab 13. Could I invite the court's attention, please, to tab 13, Professor Paul Craig, Professor of English Law at Oxford University. And I commend all of this to the court, but can I just emphasise at tab 13, the second page, in the middle of the page, and there's a paragraph in the middle. He's dealing with the argument of the divisional court. He says, if we accept such an argument, then we recast the boundaries of parliamentary sovereignty as traditionally conceived. Parliament remains omnipotent in the sense that there are no bounds to its legislative authority, but the executive can determine when Parliament exercises that legislative authority. It can choose to prorogue Parliament whenever it wishes, including in order to prevent Parliament exercising its voice through legislation or otherwise, merely because the executive believes that what Parliament might do is undesirable. The executive's decision in this respect is legally unchallengeable, irrespective of the ground on which the prorogation decision is based. If this represents the law, says Professor Craig, then every textbook, article and essay on constitutional law has missed this crucial qualification to the sovereignty of Parliament. So Professor Craig puts it the other way round. He says that if it were really to be the constitutional law of this country, that the executive may act for the purpose or with the inevitable effect of silencing parliamentary scrutiny, then one would expect to find some authority to support that contention, and there is none. We therefore submit both, as I say, that it's a basic principle of law that public powers may only be validly exercised where they are not intended, do not have the effect of undermining constitutional principle. And we say here that either the purpose of the Prime Minister or the inevitable effect of his decision is to silence Parliament unnecessarily, because it doesn't need to close for 5 weeks in order for there to be a Queen's speech, and undermine constitutional principle. What is the principle? Well, it's a principle of common law as to parliamentary sovereignty. Can I take the court, please, to the first Miller case, which is in Authorities Bundle number 2. And it's at tab number 29. Main Authorities Bundle for Miller. Bundle 3, tab number 29. I take the court first to the judgment of the Divisional Court. That, of course, was Lord Thomas, Chief Justice, Sir Terence Etherton, Master of the Rolls, and my Lord Sales. And the relevant passage is at page 73 of the report, at paragraph 18. The UK does not have a constitution to be found entirely in a written document. This does not mean that there is an absence of a constitution or constitutional law. On the contrary, the UK has its own form of constitutional law as recognised in each of the jurisdictions of the 4 constituent nations. Some of it is written in the form of statutes which have particular constitutional importance. Some of it is reflected in fundamental rules of law, I emphasise of law, recognised by both Parliament and the courts. There are established and well-recognised legal rules which govern the exercise of public power and which distribute decision-making authority between different entities in the state and define the extent of their respective powers. The UK is a constitutional democracy framed by legal rules and subject to the rule of law. The courts have a constitutional duty fundamental to the rule of law in a democratic state to enforce rules of constitutional law in the same way as the courts enforce other laws. And in this court, at paragraph 45, which is on page 138, at the bottom of page 138, paragraph 45, we're told the Crown's administrative powers are now exercised by the executive, that is, by ministers who are answerable to the UK Parliament. However, consistently with the principles established in the 17th century, the exercise of those powers must be compatible with legislation and the common law. The court added at paragraph 90, which is on page 152, just above letter C, bearing in mind this unique history and the constitutional principle of parliamentary sovereignty, it seems most improbable that those two parties, that's Parliament and the courts, had the intention or expectation that ministers, constitutionally the junior partner in that exercise, could subsequently remove the graft without formal appropriate sanction from the constitutionally senior partner in that exercise, Parliament. Ministers are constitutionally the junior partner. And the real issue in this case is whether the junior partner may lawfully remove the scrutiny of its activities by the senior partner, either with the motive or having the effect of removing such scrutiny on vitally important questions. There is, of course, a good constitutional law reason why ministers are the junior partner and Parliament is the senior partner. And that is explained by Lord Hoffman for the board, for the majority of the board, in the Banku case, which appears in Authorities Volume number 2 at tab number 23. This was the Chagos Islands case, which is very familiar to the court, and the relevant passage in Banku, it's volume 2 of the Authorities volume for Miller, tab number 23. The relevant passage is paragraph 35, which appears at page 482. Paragraph 35, page 482, Lord Hoffman, for the majority of the board, the fact that orders in council resemble acts of parliament does not mean they share all their characteristics. And then this, the principle of the sovereignty of parliament, as it has been developed by the courts over the past 350 years, is founded upon the unique authority parliament derives from its representative character. An exercise of the prerogative lacks this quality. Although it may be legislative in character, it is still an exercise of power by the executive alone. And that's why the executive is, to use this court's phrase, the junior partner in the constitutional exercise. One other authority to like effect, which I mentioned in opening, is the Fire Brigade Union case. It's to be found in volume 3 of the Miller Authorities at tab number 42. Volume 3, tab number 42. And the relevant passage is at page 552. In the speech of Lord Brown-Wilkinson, it's just under letter E on page 552. The constitutional history of this country is the history of the prerogative powers of the Crown being made subject to the overriding powers of the democratically elected, and I emphasize those words, democratically elected legislature as the sovereign body. And it is our submission that the case for the Crown in the present proceedings necessarily has to contend for the reverse, that the powers of the democratically elected legislature as the sovereign body, are subject to the decisions of the executive as to when the executive enjoys, it is said, a discretion, complete discretion, to remove the powers of the democratically elected legislature in terms of motive or effect. And that was, in substance, the reasoning on this issue of law by the Inner House, Lord Drummond Young at paragraph 99. I won't take the court to it, but we draw attention to it, that the ministers cannot exercise prerogative powers with the intention or the effect of removing the powers of the legislature. Many of the cases, of course, relate to parliamentary sovereignty in the sense that the executive cannot defy or cannot frustrate what Parliament has said. The case of proclamations in 1611, which is Authorities Volume 1, Tab 10, which we invite the court to look at, not least because Lord Coke, like Lord Reid in 1968, was not deterred by the argument there is no authority for this. Lord Coke, like Lord Reid in 1968, resolved the question by reference to fundamental principle. The argument was, leave it to the king. More recently, of course, there's the Fire Brigades Union case that the Home Secretary could not frustrate parliamentary sovereignty. But parliamentary sovereignty has also been used as the basis for other decisions by the courts. It's been used as the basis for a recognition of parliamentary privilege. In the Picken case, again, I don't have time to go to it, but it's Authorities Volume 2, Tab 19. And parliamentary supremacy was also relied upon by my Lord the Deputy President for this court in the Unison case as a foundation for the general constitutional principle of the rule of law, which meant that there were limits on the ability of the Lord Chancellor to impose fees for those who wished to bring employment tribunal cases. And my Lord was not deterred by the difficulty of identifying when a fee would become lawful. How much fee is appropriate did not deter your Lordship on behalf of the court from saying that the approach of the Lord Chancellor was an unlawful one because it denied in practice access to the courts and that was a breach of the rule of law read with parliamentary sovereignty. All of the cases, in my submission, all of the cases are simply illustrations of the basic principle of our constitutional law. And the basic principle is that Parliament is supreme. The executive is answerable to Parliament. And this legal concept of parliamentary sovereignty is not confined to cases where the executive ignores or frustrates an act of Parliament. It must also apply to cases, and this is a unique case to answer my Lord Carnwath, it's never before occurred. It must also apply to cases where the executive takes a decision with the purpose or effect of removing the ability of Parliament to legislate. Indeed, it's a greater breach, or could be a greater breach, of parliamentary sovereignty to prevent Parliament from legislating as it sees fit than it is for the executive to defy a particular law. The inferior body, the junior partner the executive cannot validly use its constitutional powers for the purpose or with the effect of preventing the superior body from performing its constitutional functions, particularly when that constitutional function is the scrutiny of the junior partner itself. That's the principle for which we contend. And there's a further analysis by Professor Paul Craig that I commend to the court. It's in the Miller Authorities, Volume 5, and it appears at tab number 79. This was published on the 31st of August by Professor Craig, tab number 79 of Volume 5. He refers in the second paragraph to the leading cases. In the fourth paragraph, he says, the salient issue in relation to prorogation is whether the Prime Minister's discretionary power should be limited pursuant to the principles underlying the case law set out above. He says the argument for an affirmative answer is compelling, and he says it's for two related reasons. First, to contend that there is some difference between the existing case law and the present situation does not withstand normative examination. The reality is to the contrary. The rationale for intervention to protect parliamentary sovereignty is even stronger than in the preceding cases. Consider the following two propositions. Parliament has enacted a statute, the executive seeks to circumvent it by recourse to the prerogative. The court intervenes to protect parliamentary sovereignty, and it does. Parliament wishes to exercise its legitimate authority through enactment of a statute or in some other way. The executive precludes this through prorogation, and the court is said to be powerless to intervene. This distinction makes no principled sense, more especially because the latter abuse of discretionary power is more far-reaching and significant than the former. The former impacts only on a particular statute. The latter constitutes a preemptive strike that takes Parliament out of the entire game for the crucial period during which it is prorogued. It affects not merely one piece of legislation, but its capacity to exercise the totality of its legislative authority, thereby severely curtailing the opportunity for parliamentary voice on an issue that, whatever one's view about Brexit, is of major importance for the UK's future. This is, moreover, the reason why judicial intervention in this instance would not signal some general judicial intrusion in this terrain. The use of prorogation in this instance is singular and warrants judicial intervention. Secondly, the case for intervention is also compelling because of the impact of the abuse of power in relation to prorogation on the sovereignty principle itself. The sovereignty of Parliament is the foundational principle underlying the unwritten UK Constitution. This sovereignty resides with Parliament, not with the executive. And he says that it represents a challenge to sovereignty since the executive in the standard case seeks to bypass an existing statute through recourse to the prerogative. It was for this very reason the House of Lords intervened to prevent this. The prorogation scenario is more far-reaching in its impact on sovereignty. The political discussion of prorogation by the present government was predicated on the assumption it could be legitimate for the Prime Minister to make use of the power intentionally. Then he's turning to intention to bypass what was felt to be a recalcitrant Parliament. This is not, cannot be constitutionally correct. To subscribe to such reasoning diminishes parliamentary sovereignty as a foundational principle. It transforms the UK constitutional order such that the cards become stacked in the executive's favour. And we rely on all of that, my lords and my ladies.
Can I ask you to, if it were put to you that that Parliament is indeed sovereign and the government's accountable to Parliament, when Parliament sat in early September, if it were sufficiently concerned about the prospect of prorogation, it could have held the government to account by passing a vote of no confidence in it. If Parliament has held its hand, should the courts intervene?
Well, my answer to that is that it is well established that the executive is answerable to Parliament for matters of politics. But the executive is answerable to the courts for matters of law. And I respectfully submit that this court is simply not concerned with whether or not the Prime Minister could command the confidence of the House of Commons, whether a vote of no confidence could have been brought, what the consequence of it might have been. That is, in my submission, no answer with respect to the accountability of the Prime Minister to this court for the legality of his conduct. And the authority for that is again the Fire Brigades Union case. Could I take the court back to Authorities Volume 3? It's at the Miller Authorities Volume 3. It's at tab number 42. And the relevant passage appears at 572, again in the speech. I'm sorry, this is in the speech of Lord Lloyd of Berwick at 572, Volume 3, Authorities, tab 42, page 572, at the bottom of the page. Lord Lloyd says this: no court would ever depreciate or call in question ministerial responsibility to Parliament. But as Professor Sir William Wade points out in Wade and Forsyth, ministerial responsibility is no substitute for judicial review. And then Lord Lloyd cites what was said by Lord Diplock in the National Federation of Self-Employed case. And Lord Diplock said this: it is not, in my view, a sufficient answer to say that judicial review of the actions of officers or departments of central government is unnecessary because they are accountable to Parliament for the way in which they carry out their functions. They are accountable to Parliament for what they do so far as regards efficiency and policy, and of that, Parliament is the only judge. They are responsible to a court of justice for the lawfulness of what they do, and of that, the court is the only judge. And we rely upon that fundamental principle. And I respectfully submit that if that argument were to be advanced against me, that Parliament could have expressed its dissatisfaction with the vote of no confidence, it is to blur the arguments of policy with the arguments of law. It is simply no answer to our submissions if they otherwise be correct. And if I'm able to show that the Prime Minister's advice to Her Majesty was unlawful, it is no answer that there could have been, in this or in any other case, a political solution. Indeed, that could always be the answer to a judicial review. It could be said in the Unison case, in the GCHQ case, in the Miller case, the Prime Minister is answerable to Parliament. But that, in my submission, legally is quite irrelevant if and to the extent, as is here the case, that the issue is a question of law.
You also seek to say that the consent of the sovereign would have been required if Parliament had limited the government's...
Your Ladyship is completely correct. That, of course, would not be an answer to the question put to me, however, by the Deputy President, because the consent of the Sovereign would not have been required for a vote of no confidence. But if the argument were to be put, and it is put, I think, in the Prime Minister and the Advocate General's case, that what could have happened was a bill to remove prorogation, to alter prorogation. This is put in paragraph 9 of the written case for my friends. That would not be available because a bill which touches upon the prerogatives of Her Majesty, this is the point your Ladyship's putting to me, and I respectfully agree, a bill that touches upon the prerogatives of Her Majesty cannot be brought forward in Parliament without the consent of Her Majesty. And Her Majesty, of course, would be advised as to whether to give consent by the Prime Minister. The authority for that is Authorities Bundle, Miller Bundle, number 5, tab number 73. And it appears behind tab 73 in Bundle 5. This is from Erskine May, the latest edition of Erskine May. And the relevant paragraph of Erskine May is at paragraph 30.79. And that says, bills affecting the royal prerogative require the Queen's consent. And that's a well-established principle. I mean, what happens in practice, I can hand this in if the court is interested, when the fixed-term Parliaments Bill came before Parliament, the second reading was preceded by the then Deputy Prime Minister telling the House of Commons, I quote, "I have it in command from Her Majesty the Queen to acquaint the House that Her Majesty, having been informed of the purport of the bill, has consented to place her prerogative, so far as it is affected by the bill, at the disposal of Parliament for the purposes of the bill." That's what happens. So in practice, no bill, as my Lady Arden points out, no bill affecting the prerogative power could have been placed before Parliament without the consent of Her Majesty, and Her Majesty would have been advised by the Prime Minister. Paragraph 54 of the Divisional Court judgment refers to examples of lengthy prorogations of Parliament in the early part of the 20th century. I am, with respect, doubtful that this court is going to be assisted, much if at all, by detailed submissions on the very different circumstances in 1930, 1914, or 1901. If it matters, we respectfully submit that there is no evidence that we found that the length of the prorogation in those cases was dictated by a wish to avoid parliamentary scrutiny. And of course, those examples all occurred long before modern judicial review, in particular the GCHQ case, recognising the exercise of prerogative powers was open to legal challenge. The 1949 example that is given by my friends, where there were very short sessions of Parliament, was to ensure that the provisions of the Parliament Act 1911 could be implemented. That was not designed to prevent Parliament from acting. It was intended to allow Parliament to act, to implement the Parliament Act 1949. But again,
intended to allow the House of Commons to act.
Well, indeed, which
not
was
Parliament,
which was permitted under the 1911 Act, as this court, I think my Lady the President was a member of the court in Jackson.
I was indeed, yes.
The court addressed that thorny constitutional issues, but that, of course, was 1949, again long before GCHQ, and we respectfully doubt that the court is much assisted by analysis of what could have been possibly legal challenges in very different circumstances. May I then turn to justiciability? And our submission is that this case raises a legal question for resolution by the court. And the legal question is whether it is an invalid use of the power for the Prime Minister to exercise it in order to avoid parliamentary scrutiny, or with the inevitable effect of avoiding parliamentary scrutiny. Again, I rely on the academic analysis. I rely on the analysis by Professor Mark Elliott, which is in Supplemental Authorities, Volume 1, at tab number 15. And can I pick it up where I left off when I last took the court to tab 15? It's on the third page of Professor Mark Elliott's analysis. The court sees at the end, incidentally, who Professor Elliott is. He's Professor of Public Law, Deputy Chair of the Faculty of Law at the University of Cambridge, Fellow of St Catherine's College. He also served for 4 years as the legal advisor to the House of Lords Select Committee on the Constitution. And on the third page, in the final paragraph, the court sees that leads on to the question whether, notwithstanding all of the foregoing, the issues are non-justiciable. The answer to that question, an answer that largely follows from the foregoing analysis, is surely no. This is so because of what, once the issues are clearly understood, the court does not need to do in order to answer the relevant legal question. Paul Craig has correctly pointed out, that's Supplementary Authorities, tab 13, that it's misconceived to suppose that the exercise of the prorogation power necessarily involves matters of high policy. Its exercise is almost always mundane. And he says it's possible to go even further in the present context and argue the issue at stake is justiciable because it doesn't, in the first place, raise any question for judicial determination upon which an argument of non-justiciability could bite. Such questions could, at least in theory, arise if a court were asked to rule on whether 3 days or 5 days would be reasonable and so lawful duration. That would raise the sort of problem referred to by the divisional court of an insuperable difficulty where the court can't make a legal assessment of whether the duration was excessive by reference to any measure. Crucially, however, no such issue arises in Miller and Cherry. There's no need for the court to determine whether the duration was excessive. This is not, however, to deny, and this is our case, that inferences may properly be drawn from the duration of a period of prorogation when a court is determining what the true purpose, or indeed effect, was. And the government's position is the government wanted to open a new session of Parliament, hold a Queen's speech. This signally fails to explain why such an abnormally long period of prorogation has been chosen and gives rise to an inference in improper purposes at stake. Thus, far from requiring the court to determine whether the duration is excessive, the issue requires the court only to determine whether, to begin with, prorogation was undertaken for a purpose that was legally impermissible because it lies outside the range of purposes for which the power can lawfully be deployed. And that's the Padfield point, with the intention or effect of frustrating the legal principle of parliamentary sovereignty. This is a crisp question of constitutional law, says Professor Elliott, concerning the scope of the discretionary power to prorogue, as distinct from a question about whether discretion has been lawfully exercised. Such a question of law about the scope of the executive's legal powers is manifestly, says Professor Elliott, one that lies within the field of matters with which the courts can properly deal. And then I draw the court's attention to the following paragraph, which adds some further supplementary reasoning, which I won't read out, only in the
Doesn't
interest.
really address the authorities in the subject. Again, it's slightly frustrating to hear a very eminent academic holding forth, but without actually any reference to the authorities on the limits of review of the prerogative power.
The authorities to which I'm coming recognise in my submission that where one is dealing with a question of law, where one's dealing with the question of whether there has been a breach of the general principles of public law, the court does have jurisdiction. And I will come briefly
Yes,
to
in a
the
way,
authorities.
I would have thought that was slightly more useful than with respect to Professor Elliott, because
Well,
I mean, this is, to my mind, one of the really difficult issues we have to grapple with.
It is.
What are the limits of review in relation to the prerogative?
Well, I just want to show you, Lordship, because it is interesting in a field of constitutional law just what approach is taken by the leading academics in this area. Before coming to the authorities, can I also show your Lordships what is said by Lord Mance on the question of reviewability in the context of prerogative powers in giving the FA Mann lecture. That appears in the Cherry authorities, Joanna Cherry's authorities at volume 3. And it appears behind tab 67. 67, volume 3 of the Cherry authorities, tab 67. I commend all of this to the attention of the courts. Yes, MS page number 3092 is the relevant passage. It begins at 3073. And the conclusion is at page 3092. And at the top of 3092, Lord Mance, giving the FA Mann lecture on justiciability, says, drawing together the threads, my thesis is that for the most part, courts can and should adjudicate upon civil claims and public law claims without it being necessary or appropriate to resort to a doctrine of non-justiciability. There are a few ad hoc situations where an international law principle in the form of state immunity or a domestic law principle such as the Bill of Rights debars the courts from fulfilling their ordinary function. But the nature of ordinary civil claims makes non-justiciability a very rare phenomenon. Judicial review can, in contrast, range wider into areas that may potentially be thought to throw up problems of judiciability, but is subject to other controls, standing, institutional competence, discretion, which commonly make it unnecessary to grasp at so blunt a response. It continues to be the area of foreign relations in which respect for institutional or constitutional competence may most easily tip over into outright non-justiciability. There can here be no single litmus test. The political question doctrine has faded from English common law thinking. Very often it will be unnecessary and inappropriate to accept the blunt argument of a no-go area. There is a continuing shift to a more nuanced recognition that each case must be approached on its merits, weighing all relevant factors to decide whether the particular issue is really non-justiciable or whether any relief by way of judicial review should as a matter of discretion be granted. This shift will be promoted by fuller recognition that the intensity of judicial review should reflect the respective institutional competence and expertise of the original decision maker, etc., etc. And he reaches that conclusion after assessing prerogative powers. That's part of the analysis that Lord Mance adopts. And I commend all of that to the court. It's similar, not the same, it's similar to the analysis by my Lord Sales, again speaking extrajudicially. If I could take the court to that, it's Authorities Bundle 5, the Miller Authorities Bundle 5 at tab number 84, under the heading Crown Powers, the Royal Prerogative and Fundamental Rights. Again, I commend all of this to the court.
Sorry, which tab? Sorry.
It's volume 5 of the Miller Authorities. It's tab number 84, my lady.
Thank you.
And at page 379, in the middle of the page, I just wanted to draw attention to this paragraph, although, as I say, all of it commands consideration. The most basic level of control of the Crown's prerogative powers is through the doctrine that the Crown only has such powers as are recognised by the courts. That is, the courts police the boundaries of prerogative power. The Crown's claims of constitutional authority are thus filtered through common law doctrine, much as the distinct claims of constitutional authority by another locus of constitutional power, namely claims of parliamentary privilege by Parliament, are scrutinised. While the common law is not exactly the source of prerogative power and parliamentary privilege, it is only to the extent that they are recognised by the common law and permitted to have operation that the authority claims which they embody are effective in law, and that involves an examination of historical claims and practices over time. And there's a reference in the footnote 88, to the proclamations case. The king hath no prerogative but that which the law of the land allows him. And we say that, with respect, is right, that the scope and extent of prerogative power is a matter for the courts to determine. The leading case...
Sorry, I know you've got a shortage of time.
Please.
But on your present formulation, the power can not be used in order to avoid parliamentary scrutiny, or with the inevitable effect of avoiding it. Does that second half of it require a bit more sophisticated formulation? Because the Fixed Term Parliaments Act expressly allows for prorogation, and prorogation will inevitably mean no parliamentary scrutiny.
I'm not challenging the existence of a power to prorogue, and I recognise, as your ladyship puts to me, that any prorogation involves a removal for that length of time of the powers of Parliament to scrutinise. But given the junior role of the executive, our case is that it is implicit in the power to prorogue that it will not be used in such a way as to remove parliamentary scrutiny other than so far as is reasonably necessary to accomplish a legitimate objective. And here, the objective that is presented is to end one session and start another with a Queen's speech. And I entirely accept that that is a decision which the Prime Minister is perfectly entitled to take. What he's not entitled to do, without a good justification, is to prorogue for a period so long that, in effect, or with the purpose, it is going to frustrate, remove the ability of Parliament to scrutinise the actions of the executive. And we say, applying the Padfield principle in the context of prerogative powers, this is a decision, prorogation for 5 weeks, which either has the intention or has the self-evident effect of frustrating the constitutional principle of parliamentary sovereignty and supremacy over the executive. But I make it clear, if I haven't already done so, that of course the Prime Minister can prorogue, and of course any prorogation is going to have an adverse effect on parliamentary scrutiny. But this, we say, is a quite distinct case, given the circumstances and the length of prorogation.
can the legitimate purposes for which the executive prorogues Parliament include the obtaining of a political advantage?
To obtain a political advantage, well, not if that political advantage is to remove the scrutiny of Parliament. No, for the reasons that I have sought to give. That, we say, is an impermissible purpose, because it is implicit in your Lordship's formulation that the executive is seeking to remove the scrutiny of Parliament. And if that is the purpose or the effect, it is not permissible. No. I mean, obviously cases are going to depend upon their facts in this context. And one needs to look very carefully at the circumstances of any particular case.
I just, in the Cherry case, reading their written cases, it seemed to be accepted by both sides that the obtaining of a political advantage could, in certain circumstances, be a legitimate measure taken by the executive.
Well, if your Lordship's putting to me, if the Prime Minister thinks, and he does, that there are political advantages in having a prorogation because he wishes to end one session of Parliament and start another in order to have a Queen's speech that will set out his programme, his government's programme, of course, I have no quarrel with that.
I think it depends on the species of political advantage that one's speaking of.
Yes.
Your essential submission is you cannot have political advantage in the form of shutting down Parliament to avoid scrutiny.
Precisely. But I've accepted that it's perfectly legitimate for the Prime Minister to take the view, as he does, that it's time to have a Queen's speech. And in order to have a Queen's speech, you need to prorogue Parliament in order to have a new session. I have no quarrel with that. But that's a very different matter, as my Lord Kerr puts it. It's a very different matter from saying what I want to do is to have a prorogation of an exceptional length of time for the purpose or with the effect of closing down Parliament so that it cannot scrutinise the conduct of the executive. That's a very different matter. And it's a vital distinction. And I'm not asking the court to go wider than the circumstances of this unique case. The authorities, my Lord Carmouth rightly says I need to address the authorities. The leading authority is volume 4, tab 47. That's the Shergill authority, Shergill and Caira. Volume 4 of the Miller authority at tab number 47. And the relevant passage, it's in the judgment of Lord Newburgh, Lord Sumption, and my Lord Hodge, speaking for the court. Tab 47, paragraph 41, which is on page 377 of the report. Letter D on page 377. Non-justiciability refers to a case where an issue is said to be inherently unsuitable for judicial determination by reason only of its subject matter. And the court said that such cases generally fall into one of two categories. The first comprises cases where the issue in question is beyond the constitutional competence assigned to the courts under our conception of the separation of powers. Cases in this category are rare, rightly so, for they may result in a denial of justice. Paradigm cases are non-justiciability of certain transactions of foreign states and of proceedings in Parliament. The first is based in part on the constitutional limits of the court's competence as against that of the executive in matters directly affecting the UK's relations to foreign states, and Boots Gas is mentioned. The second is based on the constitutional limits of the court's competence as against that of Parliament. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it's necessary to do so in order to decide some other issue which is itself unquestionably justiciable. And that's not this case. No one suggests it's this case. The second category of non-justiciable cases is quite different. It comprises claims or defences which are based neither on private legal rights or obligations nor on reviewable matters of public law. And examples are given: domestic disputes, transactions not intended to affect legal relations, issues of international law, which engage no private right of the claimant or reviewable question of public law. Some issues might well be non-justiciable in this sense if the courts were asked to decide them in the abstract, but they must nevertheless be resolved if their resolution is necessary in order to decide some other issue which is in itself justiciable. The best known examples are in the domain of public law, and then the examples are given of some of the leading cases. And we have no quarrel, of course, with any of that. Our point is that the present case does involve a question of public law, which it is with respect for the court to determine. Is the exercise of this prerogative power in the circumstances of this case within or without the legitimate legal purposes for which that power may be exercised? And the answer is either yes or it is no. But it is an issue of law, and the rule of law, in my respectful submission, demands that the court answers it and not say it's not for us, it's to be left. It's for the discretion of the minister. The minister cannot, in my submission, have a discretion. The Prime Minister cannot have a discretion as to the breadth of the powers that he, the Prime Minister, enjoys. Many cases have been cited by the divisional court and by my friends in their written case. Can I say something about them briefly? The first is A against the Secretary of State, which is in Authorities Volume 1, tab number 5, and the court will recall that this, tab number 1, Authorities Volume 1, tab number 1, A and the Secretary of State. This was the case about the detention of foreign nationals without trial when they were suspected of involvement in terrorism after 9/11. A highly political context. Our submission being the political context in which an issue of law arises does not remove of itself the jurisdiction of the court. Miller, number 1, arose in 2016 in a highly political context, but the court nevertheless accepted that the issues were justiciable. In A...
There wasn't any dispute about it.
There wasn't. No, there wasn't. Absolutely not. In A, my friends have relied on paragraph 29 of the speech of Lord Bingham, which is at page 102. And paragraph 29 arose in the context of paragraph 16. Paragraph 16 on page 96, the heading was Public Emergency, and the claimants in that case were contending that detention without trial was unlawful because, contrary to Article 15 of the European Convention, there was not a public emergency threatening the life of the nation. That's the context in which Lord Bingham made the observations at paragraph 29. At letter E, Lord Bingham said, the more purely, this is page 102, the more purely political in a broad or narrow sense a question is, the more appropriate it will be for political resolution. The less likely it is to be an appropriate matter for judicial decision. The smaller, therefore, will be the potential role of the court. It's the function of political and not judicial bodies to resolve political questions. Conversely, the greater the legal content of any issue, the greater the potential role of the court, because under our constitution, and subject to the sovereign power of Parliament, it is the function of the courts to resolve legal questions. And his lordship said that the question seemed to his lordship to be very much at the political end, but nevertheless, his lordship did not rule that the issue was non-justiciable. His lordship resolved the issue in favour of the government. It's not a case about non-justiciability. It's a case about discretion and a case about margin of discretion. Indeed, to the contrary, the majority of their lordship's house, including Lord Bingham, ruled that the impugned legislation was a breach of the Human Rights Convention. Not merely was there justiciability, there was unlawful decision because a distinction was drawn between foreign nationals and citizens of this country. And at page 110, paragraph 42, letter F to G, Lord Bingham was very critical of the submissions of the then Attorney General, who had suggested that the issues were not for judges to determine.
I suppose it's also worth bearing in mind that Lord Hoffman actually did decide.
Lord Hoffman dissented on,
yes,
on
the very point that there was
indeed he did.
An emergency threatening the life of the nation. So he obviously must have considered it to be a justiciable question.
Well, I say, and I haven't got time to take the court through the judgment, all of their lordships accepted that there was justiciability, even on that highly political question of whether or not there was a threat to the life of the nation. 8 of them held that there was no breach on the merits of the provision of the European Convention, Article 15. Lord Hoffman, as my lady the President reminds me, dissented, justiciability and a breach. As to whether the distinction between foreign nationals and domestic nationals could be challenged, all of their lordships accepted and ladyships accepted justiciability. Lord Walker dissented on the merits, and 8 members of the Appellate Committee held that there was a breach of the European Convention. The case does not assist, my friends. Gibson and Lord Advocate is the second case. It's volume 1 of the authorities. It's tab number 12. It's a decision of Lord Keith sitting in the Outer House in 1975. The context appears from page 139. This is volume 1 of the authorities, tab 12. At page 139, in the middle of the page, was the first paragraph of Lord Keith's decision. The issue was whether the European Communities Act was contrary to Article 18 of the Act of Union 1707 and was therefore null and of no effect. That was the issue in the case, and that's because it was pointed out that Article 18 of the Act of Union talks about Scots private law and matters of evident utility. And the judgment of Lord Keith that's relied upon is at 144 in the middle of the page, in the middle of the main paragraph at page 144. Lord Keith says, "I am, however, of opinion that the question whether a particular act of the UK Parliament altering a particular aspect of Scots private law is or is not for the evident utility of subjects within Scotland is not a justiciable issue. The making of decisions upon what must essentially be a political matter is no part of the function of the court, highly undesirable it should be. The function of the court is to adjudicate upon the particular rights and obligations of individual persons in relation to other persons or to the state," etc., etc. It's unsurprising as a conclusion. I would respectfully qualify Lord Keith's analysis if it is suggested that the court's only function is to adjudicate upon the particular rights and obligations of individual persons, because that judicial review has long since proceeded further than that in relation to challenges as in Miller, as in Fire Brigades Union, are to the legality of policies, decisions which have an effect on the community at large, including the individual applicant. Then there's Robinson, which is Authorities, Volume 4 of the Miller Authorities, tab 46. This was the Northern Ireland case involving the question of whether or not the First Minister and the Deputy First Minister could be appointed more than 6 weeks after the relevant date. And what is relied upon is paragraph 12 on page 398. My friends rely upon that, where Lord Bingham said matters of potentially great importance are left to the judgment of political leaders or of the Crown, where constitutional arrangements retain scope for the exercise of political judgment. They permit a flexible response. We point out that that was not a finding of non-justiciability. Far from it. See paragraph 11, where His Lordship referred to the 1998 Act and then added, but the provision should, consistently with the language used, be interpreted generously and purposively, bearing in mind the values which the constitutional provisions are intended to embody. The case of Wheeler is at volume 4, tab 48. My Lord Sales played a role here as one of the counsel for the defendants. The context, and I don't have time to go into this in detail, the context is at paragraphs 25 and 26 that Mr. Wheeler was complaining that there'd been a promise to have a referendum in relation to constitutional treaties, and he said that should apply to the Lisbon Treaty, and entirely understandably, the court was unimpressed with the suggestion that it could rule that there had been a breach of a legitimate expectation in that context. What was legitimate? In what circumstances could the Prime Minister depart for good reason from any expectation? Standard questions in legitimate expectation law simply could not be applied in that context. Similarly, the case of Maclean, Authorities Volume 1, tab 16, a judgment of my Lord Sales. Again, can I just summarise? The claimant sought permission to bring a judicial review of the confidence and supply agreement between the Conservative Party and the Democratic Unionist Party, which the court will recall enabled the Prime Minister to form a government after the 2017 general election. And the court refused leave. My Lord refused leave for that claim to be brought. Again, we have no difficulty in accepting that the claim did not raise any tenable public law issue on which the court could adjudicate in relation to the circumstances. So we have no difficulty with any of those cases. The cases in this court include Sandyford, which is Authorities Volume 3, and to which my Lord Carnwath referred earlier, Volume 3, tab 32. This was the case, the court will recall, involving the complaint that the Secretary of State was refusing to fund legal expenses for a British national who was facing the death penalty in Indonesia. and my Lord Carnworth gave the judgment for the court. My Lord, at paragraph 50, which is on page 2712, referred to the Abbasi case, referred to the GCHQ case, and picking it up at paragraph 52, your Lordship said, for the court's role is dependent on the nature and the subject matter of the power or its exercise, particularly on whether the subject matter is justiciable. Your Lordship referred to GCHQ, referred to Bentley. Bentley, of course, was the case where there was a challenge in 1994, was it 1993, to the refusal of the Home Secretary to grant a retrospective retrospective pardon to Derek Bentley, and the divisional court held that that decision was unlawful. Your Lordship said in GCHQ, Lord Roskill suggested as prerogative powers which would not be justiciable those relating to the making of treaties, defence of the realm, prerogative of mercy, grant of honours, dissolution of Parliament, appointment of ministers. Even so, it has been held that a decision to refuse to issue any pardon based on a failure to identify the possibility in law of a conditional pardon may be reviewable. It's been held that a decision to refuse to issue a passport is reviewable. In the present case, there's been no dispute the Secretary of State, in accordance with his published policies and established practice, has some responsibility for British citizens facing capital charges abroad, nor that his exercise of the responsibility is subject to review by the courts in accordance with the principles outlined in Abbasi. It's common ground. He has a wide discretion in the formulation and application of that policy. The issues turn on the restrictions on which he is entitled to place on that policy and on its application to the appellant's case. So even in that foreign policy context, there was no dispute, and the court was content to proceed on the basis that a prerogative power could be reviewable.
I mean, it was given jointly with Lord Manchester for the record, but I was...
Yes, Your Lord, I apologise.
We did discuss at paragraph 60 and following the differences between review of a statutory power and a prerogative power. We certainly suggested there were different principles applying because of the lack of a text within which one was reviewed.
Absolutely, and that's why I accept it is more difficult to apply a Padfield principle in the context of a prerogative power. But the exercise I submit is a very similar exercise. It is necessary to identify, by reference to the common law constitutional principles, what are the purposes for which this power has been conferred on the Prime Minister. And in this case, the present cases, I say there is a very clear constitutional law principle which vitally informs the exercise that the court is being invited to carry out, which is to identify whether this exercise of the power frustrates the purposes for which the power has been conferred. Other cases will raise their own problems, and we are only concerned, obviously, with the circumstances of this case. But I recognise the difficulty. I say the same principles must apply, and just as Lord Reid in Padfield said he's not deterred by the absence of clear authority, I say the same applies here. I invite the court to look at principles. Two other points very, very briefly. First, I say the court is not assisted by the power of prerogative power in relation to dissolution. First, because it no longer exists. It's been repealed by Section 3 of the Fixed Term Parliaments Act, but also because it was a personal prerogative of the Crown. It was not a matter in respect of which Her Majesty was bound to follow the advice of the Prime Minister. See, and I don't take the court to it, see Authorities, Volume 5, Tab 81, Houston's Essays in Constitutional Law, which some of us had not read before this case since university days, but it's at pages 79 to 80. And finally, we do submit that if my friends are correct and the court lacks, if this issue is not a justiciable issue, then my friends really do need to confront the question of what happens if another Prime Minister were to decide that he or she wishes to prorogue Parliament for 6 months or for a year. And it is no answer to that for my friends to rely on Dicey, who said that no court could assist, because Dicey, for all his wisdom, was writing long, long before the development of modern constitutional law, and Dicey himself recognises that any such conduct would be, quote, of the most unconstitutional character. In my submission, the court should arrive at a conclusion that if we are otherwise correct in our submissions, that this issue is not justiciable only if the court were to be driven to do so. It is a legal question that we are raising, and legal questions are for the courts to determine. The remedy we seek is a declaration, and we only seek a declaration that the advice to Her Majesty was unlawful because paragraph 60 of the Prime Minister's detailed grounds, Trial Bundle Volume 3, Trial Bundle Tab 3, at page 41 says, and may I quote, if which is denied the advice was unlawful, the Prime Minister will take the necessary steps to comply with the terms of any declaration made by the court. In those circumstances, it's denied there's any basis for quashing the order. Unless my friends indicate to the court that the position of the Prime Minister has changed, the court has been told that the Prime Minister will comply with any declaration, and we therefore see no reason to seek any order other than a declaration. I noticed the time. I apologise for trespassing on the lunch of your lordships and your ladyship. I'm very grateful for your patience. Those are the submissions I wish to make on behalf of Mrs. Miller, unless there are other matters the court would wish me to address.
It appears not. Thank you.
Thank you very much, Lady.
And I'm assuming, I'm afraid, that Mr. Hickman was not proposing to follow you. So your case is closed, and we will look forward to hearing from the Advocate General at 2 o'clock.
My ladies, my lords, in respect of the appeal from the inner house of the Court of Session, I would invite the court to recall the interlocutor of the inner house and to dismiss the petition. In addressing the court, I'm conscious that there are issues both of fact and law that require to be touched upon. And as my learned friend, Lord Pannick observed in his opening, it is intended that to a substantial extent, my learned friend, Sir James Eadie, will address the detailed aspects of the authorities and law applying in respect of justiciability. Nevertheless, it's a topic upon which I will have to encroach to some extent in order to complete my submissions. I also have to anticipate the case to be made in this appeal by my learned friend, Mr. O'Neill, and your lordships will have had the opportunity to see his written case that perhaps goes beyond, in some contexts, the decision of the inner house itself. So what I would like to do at the outset is to identify those areas, 3 areas, where we are in agreement with the decision of the inner house, or at least the majority opinion in the inner house. And the first matter that I would seek to address is this. The inner house accepted that the determination of this case does not depend upon the particular terms of the claim of right or any speciality of Scots constitutional law. That was the opinion of the Lord President to be found at paragraph 51 of his opinion, which is at MS 1209. And perhaps I could simply ask the court to note his observation that, albeit that there could be an issue as to whether or not an act was lawful or unlawful, this is not because of the terms of the claim of right 1689 or of any speciality of Scots constitutional law. It follows from the application of the common law informed by applying the principles of democracy and the rule of law. And he refers there to the Lord Hodge in the case of Murn. To the same effect is Lord Brodie at paragraph 81 of the inner house judgment, which is at MS 1226. And there he observed that there had been no contravention of the claim of right, which was part of the case which had been advanced on behalf of the petitioners. And indeed he observed about halfway down that paragraph that while we heard much from Mr. O'Neill on behalf of the petitioners, which was both interesting and stirring about a particularly Scottish tradition of holding the crown in its various manifestations to account for present purposes and not having actually identified any material differences between the applicable Scots law and the corresponding English law, Mr. O'Neill was to an extent pushing at an open door, however only to an extent. Lord Drummond-Young didn't address the matter directly in the same way as the Lord President and Lord Brodie, but your lordships may note that in his opinion at paragraphs 97 and 98, which can be found at MS 1237, he refers to the constitutional system of the United Kingdom. Now that is hardly surprising, I venture, when we're dealing with the prerogative powers which may be exercised with respect to the Parliament of the United Kingdom. And indeed, also when we come on to consider the privileges of that United Kingdom Parliament. And I note, and your Lordships may have seen this already, that this is also consistent with the written case submitted for the Lord Advocate in footnote 6 of that case. I'm afraid there are no MS references that I'm aware of. He notes, however, the prerogative at issue here is the power of the Crown in right of the United Kingdom to prorogue the United Kingdom Parliament. The legal content and effects of that prerogative cannot sensibly differ as between the different jurisdictions of the United Kingdom, nor at the level of constitutional principle, should there be any difference of approach between the different jurisdictions of the United Kingdom as regards the proper role of the court in reviewing the exercise of that prerogative. The important thing is that the correct approach should be taken in that regard in both jurisdictions. Now, for reasons which I'll come on to elaborate, I would simply wish to refer the court to some authority that underpins the proposition that in addressing the prerogative as it applies to the United Kingdom Parliament and considering the privileges of that Parliament, one has regard to common principles of public law throughout the United Kingdom. I just note in passing that the matter was addressed in the case of Burma Oil against the Lord Advocate as long ago as 1965, when the court observed that it would be highly unusual, if not surprising, if the application of these matters differed as between the north and the south bank of the Tweed. I would also refer to the case of Adams against Guardian newspapers, which was an outer house case in which the judgment was given by Lord Reed. That can be found at MS 1325. And there, at paragraph 13 of that judgment, Lord Reed observed as follows: there is little modern authority in Scotland on the issue of parliamentary privilege, but it was common ground before me, and it appears to me to be clear that the law on this matter is in general at least, and subject to any divergence arising in consequence of other differences between Scots and English law, e.g. as to procedure, the same in Scotland as elsewhere in the United Kingdom. No difficulty arises in particular from the fact that the Bill of Rights was passed by the Convention Parliament in England and had its Scottish equivalent in the Claim of Right, the latter being less specific on the issue of freedom of speech. As Mitchell, in his work on constitutional law, explains, doctrines of parliamentary privilege were more fully developed in 1707 in England than in Scotland, and it was therefore natural that the greater should be accepted as the basis of the privileges of the Union Parliament, quite apart from the natural tendency of that Parliament to refer to precedents which were familiar to the majority of its members. And that judgment was in turn approved in the case of Coulson against Her Majesty's Advocate, a decision of the High Court of Justice, essentially the equivalent of the Criminal Court of Appeal, in 2015. I should say that there are also echoes in my Lord Reed's observations of the evidence which the late Lord Roger, in his capacity as Lord President of the Court of Session, and Sir Robert Carswell, in his then capacity as Chief Justice of Northern Ireland, gave to the Joint Committee on Parliamentary Privileges, where they made clear that they were convinced that the law would be interpreted in Scotland and Northern Ireland to reflect closely the interpretations placed upon parliamentary privilege by the English courts. So it is quite clear that the decision in the Inner House and the divisional court decision in Miller did not result from any substantive difference between English law and Scots law, because as the Inner House held, in this context, there simply wasn't any such difference to be relied upon. My lady, my lords, the second matter of agreement with the Inner House is that the prorogation of Parliament does not have a direct consequence on individual rights. And the Inner House rejected the petitioner's argument that the issue was rendered justiciable on that basis. The Lord President addressed the matter at paragraph 59 of his judgment, which can be found at MS 1212. And really very briefly said, however, the proroguing of Parliament does not have a direct consequence on individual legal rights. The issue is not justiciable on that basis, and the petitioner's argument to the opposite effect on this point is rejected. And again, Lord Drummond Young, at paragraph 125, which is at MS 1253, simply observed, finally, I should express concurrence with the views of your lordship and the chair on the question of redaction of documents supplied and the proposition that proroguing Parliament does not have a direct effect on individual legal rights. So again, I seek to put that issue to one side, albeit it may re-emerge as my learned friend Mr. O'Neill presents his submissions to the court in light of his written case. The third matter of agreement with respect to the Inner House is the acceptance by a majority of their lordships that a principle of non-justiciability exists in public law and that whether an issue is ultimately justiciable will depend upon the subject matter. And that can be found, first of all, in the opinion of the Lord President at paragraph 50, which is at MS 1208. Where he observed the decision under review, which seems to be made by the Prime Minister alone, is that to request Her Majesty the Queen to exercise her prerogative to prorogue Parliament, a prerogative decision may be the subject of a judicial review, reference to Bancroft. Whether the issue is ultimately justiciable will depend upon the subject matter, and a reference there to Lord Scarman and Lord Roskell in the GCHQ case. To similar effect, we find Lord Brodie at paragraphs 83 to 85 of his opinion, that's at MS 1226. And I won't seek to take your lordships through the entirety of that passage, but again, he appears to approach the matter on the basis that there may be an issue of non-justiciability and that it will be determined by reference to the subject matter of the case. In particular, at paragraph 84, he also made reference to the Sandiford decision that was mentioned by my learned friend, Lord Pannick. I should add, however, that Lord Drummond Young dissented on this point, and I simply ask your lordships to note that can be found at paragraphs 102 to 103 of his opinion, which is at MS 1240. But looking to the majority decision in the Inner House, again, on this third point, it is clear that the Inner House accepted the principle of non-justiciability in public law, and that ultimately justiciability would depend upon the subject matter before the court. And that, I would venture, is clearly consistent with extensive authority, which is set out in our written case, essentially from paragraph 55 onwards, and which my learned friend, Sir James Eadie, will address in due course and in more detail. So again, I put those three issues to one side at this stage. The next point that I would seek to address with the court concerns the interlocutor pronounced by the Inner House on the 11th of September this year. And that can be found at MS 505. And if I might refer the court in particular to part 4 of the interlocutor, which was pronounced after they had reversed the decision of the Lord Ordinary and allowed the reclaiming motion. And it is in these terms: find and declare that the advice to prorogue Parliament on a day between 9th and 12th September until 14th October 2019, and hence any prorogation which followed thereon, is unlawful and thus null and of no effect, and discern. Now, insofar as the Inner House seek to declare the prorogation unlawful, I will take no issue with their order. But insofar as they purport to declare that prorogation is null and of no effect, I submit that they've simply gone where the court could not go. As your lordships will be aware, prorogation may be by the sovereign in person. That has not happened in recent years. I believe the last sovereign to prorogue Parliament in person was William IV. But alternatively, it may take place by Lords Commissioners acting on a commission from the sovereign. Those Lords Commissioners summon the House of Commons and the Speaker of the House of Commons to the upper chamber and declare under the authority of the Great Seal that Parliament is prorogued. These are proceedings in Parliament, and consistently with the law of parliamentary privilege, which is common to both England and Scotland, such proceedings should not be impeached in any court. And in that context, of course, I would make reference to Article 9 of the Bill of Rights, which for reference can be found at Authority 43, MS 2893. And I would also refer to the claim of right, albeit its wording is rather different and less direct, which is in the Authorities Bundle at 44, MS 2902. So my submission at this stage is that on any view, Part 4 of the Inner House interlocutor must be recalled. And I understand
it's quite a difficult concept, isn't it, Lord Keane? This is unlawful, but it's valid.
It is because the courts are not to cross the boundaries and intrude upon the proceedings in Parliament. They may make the appropriate declarator, and I would take up a point mentioned towards the end of his submission by my learned friend, Lord Pannick. If this court finds that the advice of the Prime Minister was unlawful, the Prime Minister will take all necessary steps to comply with any declaration made by the court. And that is the appropriate way in which this matter should be addressed.
Well, that dispenses with the problem, you might say.
Well, indeed. And I understand that, in fact, the Speaker's Council recognised that as far as they're concerned, Parliament is prorogued at the present time, and it is to dispense with any debate over that issue that I draw particular attention to Part 4 of the Inner House Interlocutor, because it generates debate as to whether or not Parliament should or should not be sitting at the present time.
We have got an awful lot to think about in this case, have we not, Lord Keane?
Indeed.
And whether this is or is not a proceeding in Parliament seems to me to be an extremely difficult question.
But it is, if I might venture, my lady, perhaps one